Good afternoon. We have a panel dealing with law and social change. And just as a preliminary, I might ask that if you're in the very back, that people who are in the back might move down. Or, you know, sort of, we got a lot of empty chairs up here. And that might be helpful. The notion of law and social change, of course, it's really kind of bi-directional. There's the notion that law tends to be, it's almost trite, a conservative force, okay? But at the same time, it's not invariably so. It is possible for law to engage with society in a way that does generate some change. At the same time, these days, many of us are very concerned with trying to use society and transformations in society to change law a bit, so that you put some of that transformational effort back into legal institutions. And of course, it's a kind of circular process. So this panel will be discussing some of those issues from the perspective that they have gathered over their years of involvement with law and society in various capacities. I'm simply the chair. I will not contribute more substantively. My name's Lucinda Vandervoort. I teach here in the Faculty of Law. And then we have four panelists, good cross-section. We have Bev Jacobs, who's the past president of NAWAC, and a Aboriginal activist. We have Gwen Gray, who's a retired labor law practitioner and former chair and vice chair of the Saskatchewan Labor Board. We have Kasari Governor, who's an executive director from West Coast Leaf. And we have Hester Lazard from the Faculty of Law at the University of Victoria. And I'm going to turn this over to them. I've asked them to provide you with such aspects of their experience as will shed light on their claim to speak with authority about the issues that they particularly wish to raise this afternoon. The understanding being that insight often flows from hard-fought experience. Thank you.
So thank you for that, Lucinda. One of the questions that we were asked in preparation for this panel is, given your experience or research, what strategies have been most effective in achieving social change through the law? So that's the question I'm going to focus on. So I wanted today to talk about my theory of change and an argument that I've been developing through my work about where real and effective change for minorities or marginalized people can be achieved. It's kind of interesting to be speaking about this at this point in the conference, just after Elizabeth May and the founders of Idle No More. And in some ways, what I'm going to say is a bit of a counterpoint to what they said. So hopefully that could generate some interesting conversation. I want to argue that the change cannot be achieved through democratic means. And by that, I mean real and effective lasting change cannot be achieved through democratic means for marginalized people, and must instead be sought through the operation of the Constitution. And there was a question posed earlier. It was somebody sitting in this area, I didn't catch who it was, to Elizabeth May about that process of democratic versus constitutional change. And she said both are important. And I certainly agree with that, but I'm going to argue for a tilting of the scales in one way. So recently we've been in a revitalized period of social change with the Occupy movement, Idle No More, which we've just heard about, the student movement in Quebec, and the rise in popularity of youth-driven and petition-based organizations like Lead Now and MoveOn.org. It's an energizing and exciting time to be an activist, and I think some of this is born in reaction to an increasingly radical shift to the right in federal politics. Many of these movements have utilized the language of democracy in furthering their causes, One author I've read called democracy the most fundamental term in the political language of the left. Ian Angus, who's this author who writes about social movements, talks about the shift from the labor movement to this reborn faith in democracy as being the organizing force of the left, what brings us together. By way of example, AVES, an organization that some of you may have heard of, says they have a simple democratic mission to ensure that the views and values of the world people inform the decisions that affect us all. They're a petition-based organization. Lead Now, another one, says they seek to make progress through democracy. Move On, an organization in the States that was credited with part of Obama's success in reaching out, they say they are democracy in action. That's their slogan. The Occupy movement, as we know, used the slogan, "We are the 99%." But I want to make an argument today that this language misses the mark. Democracy, with its rigged elections, corrupt politicians, of which we've been hearing a little bit about lately, the first past the post system, low voter turnout, hyper-partisanship, which we heard about this afternoon, and broken election promises, has never in the history of civilization been perfectly realized. This much we know is true. However, the real critique is this: even if the democratic dream was attainable and attained, it would fail to guarantee human rights or to capture the voice of the people as it claims to do. So let me be clear. I do wholeheartedly support democracy, even given what I've just said. I support reforms to ensure the better operation of it, including reworking our electoral system. I believe that there is a strong relationship between legal change and public opinion, which is reinforced that every time we, and by we I mean West Coast Leaf, the organization I work for, every time we speak to politicians about trying to change a law to make it more equal for men and women of all stripes. I'm going to return to that later with an example. I understand that public opinion, the will of the people, and a robust civil society is an important thermometer in showing how equal a society really is. But I don't believe that's where lasting change happens. And that's key there. Change can happen that way, but is it really sustainable change? And does it really address human rights of those most marginalized? Democracy is a fundamentally flawed instrument for effective change for those who need it most, for those who are marginalized by the law, those who are silenced in our current power structure, those who are in the minority. Democracy in its simplest form is rule by the people. It entails a number of different elements of which I don't have time to go into all of them here. But it includes a voting system that allows everyone or almost everyone to vote for their chosen representative. It includes rule of law and free and open discussion. When I talk today about democracy as a form of change, I am thinking of two things in particular: voting for change at the ballot box and advocating for change with our elected officials. The latter is what we do at West Coast Leaf. It's part of what we do at West Coast Leaf. These two things are intimately connected. An effective lobbyist is one who can show the elected politician that he or she is more likely to be elected again if they do what the lobbyist is asking for them to do. A belief in democracy requires a faith in humanity that I just don't have. A belief in democracy implies that if you just had a government who would do what the majority of people wanted it to do, then it would be a fair or just society. This is based on a rather optimistic belief in freedom, that if people were just free to do as they wished, or at least the majority was free to do as it wished, society as a whole would be better off. Constitutionalism, on the other hand, establishes authority to ensure that human rights are respected, regardless of individual desire or intent, which of course is based really on the idea that if you allow people to do as they wish, they will ride roughshod over each other's human rights. So that in fact, democracy can encourage oppression, or at least discrimination of the few by the many. Constitutionalism holds the rather pessimistic belief that justice can only really be achieved if people are forced to act outside their own self-interest and outside the pursuit of power. So we, of course, live in a constitutional democracy, in a combination of these two things. What I'm proposing today is that activists and those seeking social change through legal means are misguided in putting too many eggs in the democratic basket as opposed to the constitutional one. Not that there shouldn't be a balance, but that there shouldn't be this real imbalance that I think that is happening right now in the activist world. While there are many nuances, democracy is in the end the rule of the majority. Even when functioning at its best, as I've said, or even if it could ever be perfectly realized, democracy by definition cannot create an equal society, despite that democracy and equality are often equated. In fact, by definition, it creates a society where some people do not have their interests represented by their government. There is no guarantee that the majority will act in anyone's interest but its own, and in fact, and this is where my pessimism comes in, people tend to think of their own needs and the needs of their family before the needs of those outside their immediate experience. Obviously, this isn't everyone, but in my experience, this is the driving force behind democracy. I want to quote from Arundhati Roy here, who says, "George Bush had a 60% rating in his war on terror, and Ariel Sharon had an even stronger mandate for his bestial invasion of Palestine. Does that make everything all right? Why not dispense with the legal system, the Constitution, the press, the whole shebang? Why not chuck morality itself and put everything up for a vote? Genocides can become the subject of opinion polls, and massacres can have marketing campaigns." So I want to give a couple of illustrations about what I mean when I talk about democracy being flawed. We've all heard about a number of changes to the refugee system federally in the last couple of years. One of them in particular was the introduction of the designated country of origin list. So a list of countries that if you come from one of those countries and you're making a refugee claim, you get less rights, you get less procedural protections than you do if you come from a country that's not on that list. And while this isn't officially listed anywhere because there are no criteria for how countries get added to this list, officially speaking, it's entirely within the discretion of the minister, which is scary in and of itself. But when Minister Kenney announced this change in the law, he said that the changes were there because democratic countries should be treated differently. That refugees from countries that are functioning democracies are less likely to have valid claims. And so therefore, they're not given a right of appeal, they're given an expedited hearing, and they're given less procedural rights. My understanding of democracy is a little bit different. I don't think having a functional majoritarian system means that women won't be assaulted by their husbands and not have the protection of the state. I think that women could still very much be at risk in democratic countries. It doesn't mean that minorities such as Romas won't be persecuted in a functioning democracy. It doesn't mean that the state will protect against LGBTQ, people who identify as LGBTQ. I'm being given the time here, so I think I've just got a couple of minutes here. I once had a conversation with a friend who runs a progressive organization whose mandate it is to promote democracy through taking on key issues of concern to Canadians and trying to create change through petitions and other form of democratic expression. A very valid goal and a very worthwhile organization. I was trying to convince him to take on the issue of another big change in refugee policy, which is the changes to healthcare, the cuts to refugee healthcare. A matter that I think is a matter of life and death for some people. And in fact, it's not just what I think, it's documented, it's there. He agreed about the importance of the issue, but his reaction was, how do I convince our members that this is something they should care about? And he knows that his membership is predominantly mainstream, mostly left of center, middle-class Canadians. The conversation ended there, and the organization has never taken on a refugee-related issue as a democratic cause. His reaction was sympathetic, but showed what a non-starter concerns of minorities are within the democratic context, even within an activist context. So I was going to deal with all the objections to my arguments. I'm going to have to skip over that a little bit. So you could ask me, you can give me all your objections when you ask me questions. But I do want to give one example before I go of where some of this is coming from for me at West Coast Leaf. One of the issues that we work on a lot is access to justice, something we've heard quite a bit about here in this conference. And that issue, I have spent years feeling like I talk about it till I'm blue in the face, and talking to groups, talking to universities, talking to decision makers in government and the head of the Legal Services Society. But what I constantly get back from those who have the authority to make the decision, those in politics, is nobody else cares about this. Just organizations like West Coast Leaf and the CBA and a number of other organizations, but the voters don't care. And we know it's important, we know it's underfunded, but we're not able to do anything about it unless voters care. And so in reaction to that, we're looking for constitutional litigation, and we're chipping away at this little, with our little chisels at the law that says access to justice cannot be protected. We're trying to make it a constitutional right in civil justice, and that's partly where some of these thoughts have come from. So one objection that I just want to deal with really quickly is that the judiciary is at least charged with the mandate to think about minorities, to enforce the Constitution. It is not perfect. I am not claiming it's perfect. But the elected politicians, their mandate is to represent the voters. And the judges, at least their mandate is to protect minorities. So that's my theory of social change, and I want to thank you all for being here and thank the conference organizers.
I come from exactly the opposite side, which is quite ironic in a way. Maybe it's not exactly opposite, but I started my career well, let's go back. I think a lot of us who are my age, which is now 61, began our political career in the women's movement or the left in the 1970s, which was quite an exciting time, and I don't think, you know, when I see young people today involved, and I don't know more in other organizations, it's just thrilling to me because it's like reliving what life was like when I was a young woman. I worked for a couple of years on the Canadian Women's Calendar Collective, which got going a historical project about women in many different fields, and was very exciting and still is ongoing today with a lot of women from this community involved in that project. But one of the things that happened to me as a result of that involvement was that we used the women's press in Toronto. I don't know how many of you remember the women's press. They were the ones who brought us Rita McNeil as a sort of a side in history. But there were very many interesting women there, and they were doing a lot of press work around working women. And that wasn't something I had spent a lot of time thinking about because I came from a rural background, moving to a city, getting involved in the women's movement, and you kind of know a little bit about paid labor, but not a lot because you haven't had much experience with it. So while I was in Toronto in 1973, these women, of all things, dragged me to the artistic woodworkers strike. I don't know, any of you who were around Toronto at that time would know why I say dragged me, because it was a very, very confrontational situation. Men and women on the left primarily were arrested every day trying to put up a defense of these workers. And the strike actually resulted in a real change eventually in the way that police deal with picketers. But for me, being from small town Saskatchewan, it was just a rude awakening to the struggle of working people in Canada. And then when I came back to the U of S, I was a student during this period, in 1974, the women, how rude of them in this campus, the support workers took over their union. The union had for years been really run by the leadership arising out of the male trades, and that had, you know, they'd formed the union as an independent union in the post-war period. The small group of trades always negotiated really good collective agreements for themselves, and the women sort of got a few cents over minimum wage, and that had gone on for some time. So a very brilliant woman named Elaine Van Oder, I forget where she was a secretary on this campus, took over the union. It became a women's union, a women's executive, and they led a very successful strike in 1974. And through that experience, the women activists on the university were drawn into strike support because there were injunctions granted, but if you're a student, you could picket. You know, we weren't members of the union, so we took up some of the picketing. So after that, in that process, I met some of the, what I would call progressive law students. I thought, wow, I didn't know there were any. I didn't. I had no clue. I thought those were sort of oxymorons. But convinced me that law was the way to go, and the way I thought you could affect social change would be by doing labor law. So for my 33 years in private practice and practice, of course, at the Government of Saskatchewan and the Labor Relations Board, that's what I've been doing. Dean Clark at one point did come to me, I think in my first year of practicing, and said, would you like to come and work at the faculty and teach? And I thought about it for about 5 minutes and said, no, I'm quite happy learning how to do litigation. And then about 10 years later, after I had my children, I thought, what was I thinking? How could I have been so silly? But okay, so were those dreams or aspirations of mine that you could make a difference by being a labor lawyer realized? Was it an effective way of changing things for women? And I have to say, I don't think my role in that picture is too big. I don't think any of us could take credit for the work that women have done through their unions and what unions have achieved for women. We have to note that some women have done very well through collective bargaining, particularly in the public sector. Since the 1970s, nurses, hospital workers, teachers and the like have really, if you look at where they were in the 1970s and where they are now, it's just a world of difference. And I feel like I've kind of grown up with that group of women. Some retail workers have marginally improved. Safeway workers, Westfair, that kind of group of women who work in the organized retail stores have made some gains in their working conditions, but not particularly around wages. They've made some gains in improving their control over their hours of work and some minor benefit gains, but nothing near like what we would hope they would achieve. But the biggest gains that I think I've seen in my lifetime through collective bargaining since the 1970s has been really the introduction and expansion of human rights and collective agreements. And that touches a little bit on the constitutional issues too, because of course we're growing into the charter during this whole period, and I think some of the work that was done by the unions in collective bargaining actually informed the charter decisions. So we saw in collective agreements, we saw the inclusion of sex, sexual orientation, disability, age, race, family status, and marital status before some of the legislation actually changed. So the unions were negotiating grounds of discrimination that then became later incorporated into legislative protections. We saw the development of the accommodation framework for disability and other grounds of discrimination in collective agreements before that became a normative standard in human rights law. We saw great improvements in occupational health and safety in collective agreements, which then became more normative in some jurisdictions in their legislation. And we saw the expansion of maternal leave and parental leave in collective agreements that then became more normative in legislation and government-run benefit plans. So that's the biggest change I have seen result from collective bargaining. It's not a huge list. Certainly, I mean, I think in labor law, what you learn is, you make gains when the economy's running hot and they need workers, you'll make gains. When it's not running hot, you lose them. So you're always kind of winning and losing and going back and forth in terms of your achievements. The biggest failures, I think, in collective bargaining have been around the hiring process, that is, affirmative action, including people into good jobs, increasing the representation of Indigenous Canadians and minority groups into collective bargaining jobs. That's been a huge failure. There are a number of reasons for that failure that I think we could talk about, but the other huge failure in my mind is the limited application of equal pay for work of equal value in collective bargaining. That still hasn't achieved a normative standard. And the inability of the labor movement as a whole, I think, in Canada and the United States and elsewhere to fight the low-wage, low-cost mentality that was introduced or initiated by Walmart that has been so hurtful to the lives of working people throughout the world. How did the work I do, when I look back, first, or how did the work I do affect social change? Were there highs and lows? And there was a brief period of my life where I worked in the Department of Labor in Saskatchewan doing legal analyst work in the 2003-2004 period. And that was a period of incredible intensity of review of all of the labor statutes in Saskatchewan, which of course is now going on the other way, backwards. But during that period, I found it really interesting because I'd always been in private practice, so going into work in government was very interesting. And I think I actually had more impact in that role because I was dealing with legislation that affected way more workers and way more people than the typical kind of one-off case that we get in private practice. Most times in private practice, you really don't choose your cases. They come to you, and you do that work, and most of the time they only affect one or two people, although there's some cases that will have a bigger scope. So I actually think that work, that kind of work is, if you want to do progressive or have an effect progressively on labor relations, that's a good place to be. In terms of one-off cases, I think that the most difficult work I did was at the Brooks XL meatpacking plant in the strike of 2005. And that was a really interesting dynamic because not only was it immigrant workers, mostly Sudanese and people from third world countries who worked there, the dynamics were absolutely fascinating. And also listening to the women from Idle No More today, you realize the RCMP tactics were no different. I mean, the RCMP were out in such force at Brooks. They were complaining to me every morning at breakfast, and we were all staying at the same hotel. There were only about 2 hotels in that town. The RCMP were taking up most of the space. And every morning, well, when can we go home, Gwen? Are you going to get that strike settled today? When can we go home? But they were out. They had, I think, almost more RCMP than there were people picketing. So it's rather interesting. And I think the assumption underlying it was racist, really, that these are people we don't know. We don't know what they're going to do. They're black people. You know, we're not sure what's going to happen. And the curious thing was that the only violence that happened there was caused by the management, who tried to basically kill the union president. So that was the high part, or an interesting, intense, and in the long run successful period of work that I had the privilege of belonging to. I just want to talk really quickly about what strategies do I think have been most effective in achieving social change through the law. And there are a lot of people in this room, I think, who could speak better to it than me, but I'm just speaking from the perspective of a private practitioner. Lawyers have a terrible disease, a really, really terrible disease, and it's called know-it-all. Lawyers assume when they're acting, a lot of lawyers, and I put myself in the same category, when you're acting for progressive groups, that you know better than them what they need. And it's such a danger and such a pitfall of our practice. To advance the law, you really need to select your cases carefully. And there's one lawyer I worked with at Chivers Carpenter, which was the last firm I was with in Edmonton, was just a brilliant lawyer and very strategic in the cases he would take. And we have an arbitration roster in Alberta where sides never agree on who to use for an arbitrator because the list is so bad. And what's the employer got to lose, you know? So my partner, David, would pick, if he had an important case, pick about 5 or 6 plaintiffs or complainants and file their grievances in the same way, send them all to the list, get the arbitrators appointed, and then only run the one with the arbitrator we thought we could win with. So very effective. You don't always have that liberty. I just finished my career doing a Supreme Court case that dealt with privacy, and the facts were just god-awful. You know, it was just one of those things you couldn't avoid taking up, even though you would have wished your clients had been seeking your advice sometime in advance of the facts developing. But the other point I want to make is that you have to really be careful as lawyers advancing cases that you want, where you want to change the law, to watch what you're asking for, because it can come back to bite you in the butt really badly. And there's one case that I did, and it comes out of some labor board cases in BC, where you talk about employers shouldn't be allowed to require people to force them to listen to anti-union messages. So when there's an organizing campaign going on, they shouldn't be allowed to play movies and videos that, in the workplace that force people to listen to an anti-union message. And of course, you know, the legal bar is really small, so the next time I had an injunction case involving picketing, which goes to the labor board in Alberta, we're saying, well, the picketers have the right to stop people to communicate their message and blah, 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 and the lawyer on the other side said, you can't force listening. So I thought, oh, touche. You have to really be careful. And the other case, comment I would make on that, just coming out of cases like the Vren case that was done by Sheila Greco in the firm that I worked with, you really need to round up, if you want to do a successful charter challenge or a successful development of law on a big issue, you really need to round up the community. You need to have a broad base of people to talk to. You need to have all their support, the academics, the community involved in the particular situation, and of course your really excellent legal team. The challenges that I see are pressing for working women in particular and workers in general are in this country achieving access to good jobs for Aboriginal people, disabled people, and youth. So that to me is just an absolute priority. I think we need to achieve access to meaningful collective bargaining and not collective begging, and that's my problem with the Constitution. The Supreme Court has only given unions collective begging. So what do we do with that? The unions really have given up, I think, or I know the Saskatchewan challenge is going up, but really what the Supreme Court says is you have a right to collectively beg. Well, we already have that right, so we'll just go back to what we're doing, which is organizing and causing havoc and making employers somehow pay attention. And the third thing is the living wage. I would add daycare too, but you already heard me on that. Thank you.
Good afternoon. Thank you for the opportunity to be invited to come and present today. My real name is Usask, and it means she's visiting. So, and I was given that name as a child, and it's quite appropriate in the work I do today and what it means. I'm actually very, I don't know, my fuel was, or my fire was fueled after the Idle No More presenters, because we've been doing this for a long time. And so it frustrates me sometimes when we have to make those kinds of presentations, and it does become very emotional because of the historic traumas that our people have had to live through and still living in. So so I want to actually, that was the focus of my my presentation today, to talk about, you know, this power this power in law to promote social change. And so all of the time I'm thinking, whose law? Whose law are we talking about? Because I always, hear this, and I've been involved in Caledonia. I was part of the negotiating team and helping our traditional council. And you saw a picture of Six Nations, Grand River Territory. That's where I come from. And so this is very emotional, even as a lawyer, as someone who comes from that place. And I know Catherine Hensel talked this morning or yesterday about that connection and being a lawyer and making those kinds of arguments in a Eurocentric legal system, and how difficult it is to do that because you are emotionally attached to it, and there's no spiritually attached to it. There's no way. I can't separate being Mohawk from being a woman to my land and my territory. I can't take myself away. We're directly attached to it. And so even in acknowledging where I come from and coming here to Treaty 6 territory, and acknowledging the Cree peoples here and the Métis peoples and the historic places here, that it's like that everywhere. There's a historic place for Indigenous peoples in every part of North and South America, because those are our traditional territories. That's where we come from. In any place, there's a connection in where you come from. And so I've been gifted with many teachings. I was raised in my community with the Haudenosaunee Confederacy. I was raised with chiefs and clan mothers and faith keepers, and made a decision to go to law school. And that decision was made for a number of reasons. One of them was I was a single parent. The other was I was a legal secretary and a law clerk. And I was going from lawyer to lawyer. So I went from corporate law, insurance law, to real estate law, criminal law, family law. It was pretty monotonous as a legal secretary. But also at the same time, I was thinking, shit, I can do that. I'm the one doing the work. I'm the one doing it. So by the time I got to the last lawyer, family law lawyer I was working with, and discussing the possibility, and actually what happened was my mother was dying. And so she died in 1989. And then Oka happened, 1990. And then, so all of those things were happening all at the same time, around the same time, and making a decision to go to law school, and talking to my father at the time. My mom was already gone by then. And making that decision, and he was really worried. He was really worried about learning about the colonizers' law. I had the same emotional breakdown when I came here and doing my master's in law thesis and my coursework and graduating from here with my master's in law and working on our traditional law and where we come from, and then speaking about Eurocentric law and how it's had an impact on our people, and I just completely broke down. And a big part of that is because appreciating Lynn Jenkins' presentation on trauma, and she's talking about vicarious trauma, But I live the trauma. I'm part of that. And understanding how this trauma has an impact generationally. So what is called historical trauma. And that it carries from generation to generation until we say that's enough. That's enough. And so when I'm talking about things and talking about today about social change, is talking about violence and talking about ending violence. Because racism is violence, colonization is violence, all of these things that are impacting our people historically to this day is violence. And our people are standing on the front lines, and the reason why we're standing on the front lines is because we are protecting Mother Earth. We are protecting her for everyone. This isn't about race. This isn't about, I want to protect this because of who I am and where I come from. We're protecting this for all of humanity, for protecting for our 7 generations from today. And so in the work that I've done, in understanding this, and it took going to law school and doing my master's and now doing my doctorate, to all of these years to understand where things are going and what things need to happen and where we're coming back to. So I want to share, and I'm sure most of you, if you haven't, know this teaching of the Turo, the Gus Wenta. If you haven't, it's actually in the Native Law Center, and it's on the top of the courtroom. And it represents a relationship with the colonizers. And I always talk about how it's about a healthy relationship, that we live together on this river of life, respecting each other's way of life. Right? There's 3 basic principles within this: peace, trust, and friendship. That's like 3 principles, basic principles of a healthy relationship. So having peace with each other, trusting each other, and it's not even each other, it's we also with ourselves. So having peace with myself, my nation having peace, and trust. I have to trust myself before I can trust somebody else. And having friendship. And friendship. So these are really basic principles, but they're powerful. And this was a sacred relationship that was established. And we're all descendants of this relationship. And that we have a responsibility. So in this line represents our canoe. Right? This holds our laws, our culture, our beliefs, our language, everything about who we are as a people. This is what is carried in our canoe. And this was their ship. Held their laws, their customs, their beliefs, their language, everything that identified who they are as a people. And this relationship was made with the Dutch, with the French, with the British, and with the United States. And we just celebrated this summer 400 years of this. We had a big celebration in New York City with the Dutch people. And we flowed along the river of life in the Hudson River. And so there were paddlers. There were paddlers that celebrated this relationship and wanting to reunite it, to revitalize it, because this relationship has been violated over and over and over and over again. So if we talk about British the British relationship, right? All of the colonial laws that we're learning in law school comes from this system. And those colonial laws are rooted in violence. It's rooted in patriarchy. That it was okay to beat your wife. It was okay to rape your wife. It was the law. It was the law that men could have power over women because women were nothing. Women were property. But you know what? That didn't occur in my culture. That didn't happen in my historic beliefs and where we come from in our culture. And so I want to share this one with you. And this one is at least 1,000 years old. And this is one of our wampum belts called the Women's Nomination Belt. And this is just one little tiny piece of the Great Law recital. And it talks about the role of women and the strength of women. And that women were honored for who they were and who they are because they carried life. We're the ones as women to carry our children, to carry our babies, to carry that spirit from the Creator and to create future nations, right? And that we teach them how to be good people. That was our teachings, was to be good people, and that we have a strong relationship between the Creator and our mother, and that it was women who had that responsibility to carry that. So they say that these connections between women is the strength, and that we have this connection to our mother, the earth, and that's what this represents. Not only our mother, but our longhouses, our homes. And that we have a responsibility to our clan, to our children, male and female, in teaching them how to be good people. And that the women were given that responsibility to be decision makers because they have an instinct that men don't have. And men honored that. Men honored that decision-making power because they knew that. Because they knew that they were the protectors, right? They're the ones who are protecting us, to provide for us, to honor the balance. Because it was always about balance. And that's what this also represents, was about balance. You know, I use this a lot to show, even amongst gender relations, that we already had inherent equality. That was already part of our societies, that women were honored and the backbone in our communities. And that they were part of that life-giving, and there were ceremonies. There's ceremonies that talk about the role of women and her connection to our mother, the earth, and the Creator. And so that acknowledges the strength of our women in our societies, and that you know, we're talking about social change. Well, the social change that happened is that violence against our women occurred because of colonialism. That the violence came into our communities because of this colonial system that was forced into our territories. We had no choice. Right? All of a sudden you have the British North America Act of 1867 that says we have control over Indians and lands reserved for Indians. That was a unilateral act. And now it's in the Constitution Act of Canada. All of a sudden we're wards of the crown, and we're children, and that we can't make decisions on our own despite this treaty relationships, nation to nation relationships, and women being part of the decision making. And so this violence that has been enforced And now we're dealing with the highest rates of violence against Indigenous women in the world. You know, I've had the opportunity to meet Indigenous women around the world now. I've been very privileged to be in places where I never thought I would be when I started law school, and leaving my home community, and at that time realizing how this law was used as a tool of assimilation. It was used as a tool to erase us as a people, to annihilate us. But it didn't work, did it? Which is where what I want to talk about now is because, you know, we have this whole process where we're waking up, basically. Because when we're talking about violence, right, you lose your voice. Right, this whole colonial system is violence. And when you lose your voice, you also believe that you're not worthy of a voice. That this whole process is about self-worth. Right? When we're talking about generations of the whole residential school system, you know, and what they did to our children, well, first they attacked our women through the Indian Act system. So they weren't successful with that. But I also call that the first phase of missing women. The first phase of losing our women through that Indian Act system, because those who married out were forced out of their territories and their communities. They weren't allowed to come home. So they lost that disconnection to their lands and their territories and their ceremonies and their language. And they were cut off. And so it's really, really important to understand how this whole system has had an impact, and talking about this impacts of violence and colonialism. But I want to leave on a positive note, right? And talking about resilience. You know, and talking about me being able to stand up here to say what needs to be said because it needs to be said. And taking this role now as a lawyer within this system and trying to figure out, what the hell am I doing here? Right? But taking the words, taking this whole process positively and saying, you know what, I got the best of both worlds. I have this traditional system that I grew up in and still believe in, and know that it's still, this is where we're coming back to. But also figuring out within this system, because a lot of our people are stuck in this system, and figuring out how to make things better for our people. But ultimately, it's coming back to this full circle. Coming back to it full circle, because we already had inherent equality. We already had this process of respect of women and the respect of our lands and territories. Our rule of law is to protect lands and territories. That's what our law says. And our law does have an impact on humanity, because we need to do it today to protect future generations, to make sure they have somewhere to live. So I want to leave it there. And I need to honor a couple of people who are now gone, who have helped me with my presentation today, is Patricia Montour and Kate Montour. One of the messages that Kate left, she's 16 and committed suicide, was about the right to celebrate. You know, and to be positive, to change our language, to change how we talk about things, because we're moving towards this way of life. So in honoring them is important. Honoring those of our ancestors who are doing and helping us today. And to understand that this changing this language about violence is now about being safe and about having safe communities, safe lands, safe water, all of these things that have an impact on humanness. So thank you for the opportunity. Yawa.
Okay, so I'm very conscious that I'm the caboose on this incredible, not just the panel, but the whole conference. I think this is sort of all drawing to an end, and it's been wonderful. And I'd like to start by thanking first the people of Treaty 6 on whose territory all of these conversations have taken place. Thank you to Lucinda and to the organizers of this conference, and thank you to my fellow panelists, and especially Bev for sharing the wampum belts. I'm going to speak. We were given, I think actually all of us were given these sort of questions that were pertain to each of these workshop sessions. I'm going to speak to the question or to the theme, which was, it asked basically, well, what significant changes have you observed in your time, which for me is my time as a legal academic, which is some 20 plus years, and what do I see as a future challenge? And so in relation to that theme, I'm going to talk about two things, okay? One of them quite doctrinal, because I am, after all, a law professor, and one of them strategic, and both of them pertaining to the links between equality in the broad substantive sense and what I call participatory inclusion. So deliberately using a word that is, I think, more fundamental and broader than democracy, but actually which reflects some of the things that are captured by democracy. And I'm actually ultimately really where my thinking on this is going is more about the interconnections between things like constitutional values and participatory inclusion. So these two things, one doctrinal, one strategic, are united by the same preoccupation, namely the issue of creating space within law for voices that typically are marginalized or accorded very little weight or are completely excluded. So to start with the first one, and this is the sort of doctrinal one, so law narrowly understood as a positivist science and a set of formal institutions, courts, legislatures, tribunal rooms, is a very tightly controlled arena of elite discourses by judges, lawyers, legislators, and policymakers. And of all of these, the courtroom might, in some way, probably remains the most difficult and exclusive arena to access for some voices. But when I look back on the past 20 years of legal doctrine, something that I teach in my work, one change that I think is remarkably significant is the recent Sex Workers United Against Violence standing case, which I think goes directly to this issue of what voices we include in law. And I think that we've seen a stark historical change in the last 20 years, and 20 years seems to be the sort of time that we seem to be reflecting on in this conference. Since the Canadian Council of Churches decision 20 years ago in 1992, which was probably the low point in the Supreme Court of Canada standing jurisprudence. And 20 years later, the sex workers case in September 2012. And I think there is really something of a sea change in judicial attitudes, although I'd like to see a larger change. But still, it's something I think to notice and remark on. In the case, Justice Cromwell for the court, so unanimous decision, asserts that one of the ideas that animates public interest litigation is that it may provide access to justice for disadvantaged persons in society whose legal rights are affected. Now that is not a storm the barricades statement, especially for anyone in this room. But in fact, looking at that statement against the background of the previous decisions it is a significant shift at any rate. Previous decisions have prioritized the court's role in upholding rule of law, have prioritized not the citizens' access to justice, but the court's access to issues of constitutionality placed beyond its reach by, say, the form of the laws, is sort of often how that story goes. And the understanding, of course, has been all along that by emphasizing the court's access, allowing it through granting standing to these public interest groups, we are, of course, all benefiting by allowing it to perform its role of upholding the constitutional order and rule of law. But of course, in the real world, that has not been true. There is much inequality in how rule of law is experienced on the ground. And in the Sex Workers United Against Violence case, the organization was seeking standing in order to argue that criminal laws regulating prostitution are in fact placing the members, the constituency that they represent, placing them in danger and thus violating a range of their charter rights. And to just give you a sense of sort of the breadth of that claim, one of the pieces of testimony in the Missing Women's Inquiry that was held in the wake of the notorious Picton case revealed that 911 operators were instructing sex trade workers who called for help from Vancouver's downtown east side to get off the line, that they were inappropriately overburdening the emergency service and that the 911 service was not for them. So although there was rule of law in the formal sense for those women, they really existed in a zone beyond its reach. So the sex worker standing case against this backdrop is, I feel, in a sense, a kind of person's case. And to just quickly summarize what the key doctrinal shift was, and I'm not sort of going to go through all the steps, which many of you will be familiar with, but basically, I mean, it's an interesting case in the sense that not one word of the governing test was changed, and it's still, you know, if you went to law school 20 years ago, it's still the same test, like literally word for word. But what Cromwell said was basically we have to take a much more sort of flexible, purposive approach to it, one that is more directly tied to the applicant's experience of rule of law and questions of access of justice from the applicant's perspective. And I think that there's sort of two things about the case that are worth sort of noting about it. And one of them, I think, is probably too strong a claim to make about it. It's the kind of claim that law professors often like to make by sort of doing a close reading, but I really think it's more an emergent, perhaps, aspect of the case. The other is, I think, definitely there and very significant. But the first one is this notion that experiential knowledge is valuable. Cromwell, when he described Sex Workers United Against Violence, the organization, basically what he said was, here's an organization whose objects include improving working conditions for sex workers. It's run by and for current and former sex workers living in the Vancouver downtown east side. The society's members are women, the majority of whom are Aboriginal, living with addiction issues, health challenges, disabilities, and poverty. Almost all have been victims of physical and or sexual violence. And he took a lot of that, and it's quite clear in the case that he saw that as particularly germane to the second sort of question in the three-part test, which is, is the applicant serious, or is this simply a busybody that is going to be wasting scarce judicial resources? And so it was clearly germane to that, and what I would like to hope for is that it actually would be germane on a more fundamental level, actually, to the third question, which is whether there is any other reasonable way to have the issue come before the court, because I actually think that the knowledge that they brought to the issue just by itself, all other considerations aside, really should have been really the exclusive basis for the decision. But there was a recognition, and I guess this is the second thing which I think one can more confidently claim about what is significant about the case, which is that there was a recognition that the court's role regarding rule of law, that sort of traditional notion that public standing will be granted if it's, in particular, if it's a situation where there's no other reasonable or possible way for the court to address the issue of a constitutional violation. That basically what Cromwell said here was that, in fact, where you have this kind of issue, which is about a systemic, sort of comprehensive, cumulative set of impacts that are causing the claim about a violation of rights, that it makes absolutely no sense to say that there are other avenues through individual prosecutions to get at something that is so sort of deeply embedded in in a very complex regime, in a number of provisions. And that, in fact, he kind of turned the whole question at that third step on its head, if you compare with what went on in the church's case, and said, basically, I think a comprehensive declaratory action is the most reasonable and effective and economic use of resources, that in fact this is the way to go. And so I think that is a shift in the court's understanding of its own role and of its possibilities and responsibilities in terms of constitutional adjudication, reaching out and including those hitherto silenced voices, and thereby giving rule of law perhaps more substantive purchase in their lives. And so I think that that is very much worth noting. But I also think, and I suppose this is where I would be parting company with Kasari a bit, that it's too easy for us as lawyers to get drawn into these doctrinal victories, into these shifts in canonical texts like Supreme Court of Canada decisions, and make too much of them. For meanwhile, in fact, the body count of the women represented by Sex Workers United Against Violence continues to rise. And indeed, just this past week, I opened the local paper in Victoria to read that the body of Lisa Ann Zielke, a sex worker with addiction issues, was found in a park in Surrey, a suburb of Vancouver. So it's certainly important to have a decision like that, but would seem and it does open up a bit more space, I think, for voices within the law. But those voices continue to be stifled in all sorts of contexts, not just courtrooms, but also contexts like the Missing Women's Inquiry itself. So that in some ways, I think that the only thing that has changed is that this sort of thing now gets a little bit more reported, okay? And that's not a small thing, but it still falls far short of justice in the form of these basic protections for security and life. And so I think it's important for us as lawyers to think about whether enough has been done to give members of groups like Sex Workers United Against Violence a real and meaningful voice in decisions about law, policy, and the resources required to address the social injustices that they face. And it's here that I really turn to something that I've been doing a lot of thinking about lately, which is a social movement approach to law. And I think that we need to recognize what one American feminist scholar, Reva Siegel, calls the jurisgenerative nature of social movements and of civil society groups like Sex Workers United Against Violence, like Idle No More, like numerous other groups. And that is and what Siegel means by that is recognition of the fact that they are rightly authors of the meaning of basic constitutional guarantees, that they are not simply supplementing judicial articulation of the meaning here, and that they should be included as of right, not because it simply makes better laws or it's more efficient or a better use of judicial resources, although it does do all of those things, but because it's their entitlement to have a voice in the ordering of their safety and of their social relations. And to this end, I've been looking recently at the role of human rights discourses and the role that they've played in the global women's anti-violence movement, a movement that over this same 20-year period has been steadily growing and is often touted as a very successful example of transnational feminist activism, using law in a kind of political way, not simply in the courtroom or tribunal room or before international committees. And my focus in coming to this has not been specifically on anti-violence per se, but looking at this in terms of what I can learn about women and poverty. And of course, poverty being very related to violence because it so often intensifies women's vulnerability to violence. And I think that there are lessons for us in Canada about the relation between law and society, and about the role of social movements in relation to law and social change to be taken from this work. And the thing that I found very interesting and actually quite inspiring and intriguing here is the fact that the international protections for economic and social rights under the International Covenant for those rights to which Canada is a signatory explicitly identify participatory entitlements as a component of such human rights protections. So this is actually to go into a completely different category and actually try to contest the binary that you were setting up. Speaking here to sorry. In other words, at least if you dig down into the committee deliberations on the covenant, what they are saying is that states not only have a responsibility to provide minimum social and economic security, but they have a responsibility to put in place processes that ensure that those at whom such protections are aimed have a meaningful voice in determining the scope and character of such protections. And so I found that quite interesting. And another sort of piece that I found very, very significant, which I think actually goes even way, way further than that, was a report by the Special Rapporteur on Extreme Poverty and Human Rights just this past March in 2013. And this is a rapporteur appointed by the Human Rights Council to report on a specific topic, and here it was extreme poverty and human rights. And in this report, what she asserted was that the whole thing is about participation, okay? So it has this title, Extreme Poverty, Human Rights, starts right bang off about participation, and the whole thing sort of is all about participation. And her first sort of line of argument is that the lack of participation is the cause, not the consequence of poverty. And that is to turn an argument that I think many of us are very familiar with. Again, sort of on its head, we've heard the argument, we have to do something about minimum material supports, otherwise people can't exercise their political rights of expression, et cetera, their sort of classical negative rights. Well, she's actually sort of turning that around and saying, no, we need to have actually meaningful self-determination if we are going to address in an effective way poverty. And she goes on to set out in detail a blueprint for including the voices of persons living in poverty that states who bear the primary responsibility, so states like Canada, can rely on for developing participatory frameworks. She explicitly addresses issues pertaining to women's voices, the need to consider separate spaces, the voices of Indigenous peoples, the need to recognize their own institutions, laws, and practices around participation, and the voices of migrant workers and the way in which often their situation precludes any meaningful participation. And so it's a very nuanced, very detailed, this is not sort of a lot of bland kind of, things that we could all agree with. It actually gets down into the micro level detail and some of the really difficult issues about how to configure spaces and how to deal with the intersection between time and space in thinking about participation. So I think there is much we can do in Canada with this framework, that we have many resources to draw upon here in terms of the work being done by activist grassroots organizations, such as LEAF, such as Together Against Poverty, such as Sex Workers United Against Violence, such as Idle No More, on participatory practices that can assist us ensuring that our own versions of democracy and human rights that we don't let them fall into separate categories, and that we don't let them fall short in the way that they so often do. So I think we need to draw on, I really sort of in the long term, what I sort of am sort of orienting myself towards is making an argument on bringing that expertise to bear, the expertise of social movements who take a participatory approach with respect to the invited, more formal spaces of law and policy deliberation in ways that challenge the emptiness so often of those spaces and those practices, those consultations, those commission hearings, that often are so much more about managing resistance than they are about inclusion and equality. And I think this work on participation is fundamentally important, not simply because it recognized the standing of the most marginalized members of society legally as persons, but also their standing epistemologically as knowers, as bearers of important and distinctive knowledges, and finally, of course, their standing politically as citizens. So thank you very much for your patience at the end of this day, and I hope we do have some time for
So at this time, we can take some questions and comments if there are any. We have a mic that will help you be heard. Any comments from the floor over here?
Thank you for those presentations. I have a comment basically to make with respect to the sex workers case. I totally disagree with the approach and thinking of the Supreme Court and the presenter that it's such a great case, because I feel that it's basically whitewashing. The situation is whitewashing what's happening for women. We're using the euphemism, like the economic language of a sex worker and the sex trade to describe a form of imprisonment or enslavement of traumatized women in a role that is dishonoring of their inherent dignity and worth as women. Their bodies are treated as a commodity, and that role is celebrated, and I think that's not acceptable. And I believe the criminalization aspect should be targeted to the pimps and persons purchasing sexual services, as has been the approach in Denmark. And I feel that the case actually supports pimps more than women. And I think we need to end violence in the sex trade. We need to end the sex trade and bring other forms of economic and social and community support for the women caught up in that situation. Thanks.
Thank you. Are there comments? Any panelists want for me? Hester?
Yeah, I would just say I just want to make it clear that I'm talking about the standing case and not the actual substantive case that then went forward. And I agree, there are like really tough issues even about the choice of words that have generated a lot of controversy. The case, what I think is significant about this case is just the, I mean, some would say this is like a small shift, but the willingness of the court to actually say, you have standing to come before us and submit your affidavits about the way in which you experience your security of the person within your neighborhood and your lives. And it was this sort of recognizing their standing to speak to the court to this issue that I thought was quite, and the court's recognition that its past jurisprudence had, in fact, been precluding them from including having those voices come before the court. So it's that piece of the decision that I wanted to emphasize. But.
Right. Are there? Yes. Yeah. Please.
So I represented West Coast Leaf at SWAV at the Supreme Court of Canada, and for us it was a really important distinction that, Hester, you just pointed out. But I do want to say that the standing decision itself, I think, was was in quite a real way very empowering for the women who were involved. And that was partly through the role of counsel, not intervenor counsel, not myself, but counsel for the women, Katrina Pacey, who had worked with the women for a long time and didn't kind of swoop in as a lawyer to represent them. And I think, Hester, it brings me to a note I made when you were speaking, which is that I think it's actually important for lawyers to know that that litigation can have a real impact, because so often it hasn't been recognized and therefore it doesn't have a real impact. Because lawyers go in and make their legal arguments and it's completely detached from the reality of what women or what their clients are experiencing on the ground. And I think SWAV in some ways was quite revolutionary in the court, but I also think it was revolutionary in the way that litigation operates to actually empower people, that a whole bunch of women from Vancouver in the downtown east side flew to Ottawa, were in the courtroom and took a whole bunch of pictures with red umbrellas on the steps of the courthouse, and were very empowered by that process. And I've spoken to some of them since, and it was quite an amazing experience. So it was both in reality and in the courtroom, if I can say it that way.
I have a
Thank
question.
you. We have another over here.
I want to just pick up on that, Kasari, that you just mentioned in terms of Aboriginal women and Aboriginal people in power. And, you know, I remember going up north to teach some students some classes in Iqaluit, and we were going through some charter principles. We were brushing up on the charter because they had not done well in that class. And as we were going over the principles of the charter, one of them said, "How come those don't apply to us?" And what do you say in a moment where in academia and even in our practices we pretend that those are principles that matter and stand for something, and that they're watermarks and benchmarks and all of those things, and they're actually not? You know, in your work, when you're being told women in countries that come from democratic countries have to be fast processed, they can't possibly be being treated as badly as they say they're being treated. Well, let's look at Canadian women. Let's look at Aboriginal women and see how they're being treated. Oh wait, they're missing and they're dead. We can't talk to them. That's so ironic that nobody is looking at the Indigenous experience here in our own country and saying, those women are dead, and not just dead, not accounted for. And so I want to turn to democracy, and I want to turn to my own personal professional calling and say there has to be a place in there somewhere. But the reality is what Bev gave us. The reality is, even though people died in the streets for union battles, even though women are dying in the streets that are working in prostitution circles, we are not being heard. I don't know where our voice is going to come from. I would love to have a civil society movement in Canada and see if we could organize that way. I don't know if that's the answer. I see us as I don't see us. I don't see Indigenous people in those markers at all, and it scares the hell out of me.
Is there anyone who wants to follow through with this sort of forward-looking thread in particular as to what now?
I'm not sure that's exactly where I was going, but maybe it has a connection. My questions kind of migrated as I listened in sequence to all four of you. And so I guess what I'd like to do is start from Hester's point that this need not be necessarily a binary, opposition between using democracy or democratic processes and trying to get more participation. I think that connects to what you're saying. Versus, using constitutional processes or maybe human rights processes to get protections for minorities and historically disadvantaged groups. And, Gwen, your talk made me think, I think you talked about how a lot of gains were achieved through collective bargaining before they actually arrived in human rights documents. And there's something interesting there. Like, can we make a connection between the struggle in the union movement and then knock-on effects in terms of, you know, legislation, I guess. So those were kind of the questions going on in my mind, and maybe people can take up Marilyn's question as well.
I think what we've lacked for a number of years, and not I don't think you can assign blame or guilt for it, but we've had a certain inability to form long-lasting coalitions between different groups, labor with Aboriginal. There's been a lot of antagonism over certain issues between those two groups that we've not been able to overcome. Women with labor in certain circumstances and the like. So the forming of coalitions of those social groups is so key, in my mind, to making effective long-term social change. And I don't see anything in the labor movement that's happened since, post-war that didn't come about through those coalitions. I mean, the 8-hour workday, all of those kind of big issues, workers' compensation, unemployment insurance, didn't come about just from labor unions. It came about from a whole coalition of people saying, enough, it's time to change. And I think really that's what I Don't Know More is doing. It's bringing together a broad group of people, really, under a very different framework of looking at the earth. And that's environmentalists have been out there working for years, but we haven't seen anything as exciting and dynamic as what's happened with I Don't Know More. So I think that's the key, and there is some academic work being done on that notion of how do you form long-lasting coalitions. I certainly am not an expert in it, but it's a very, very interesting thought and field of study, and for lawyers too who want to do progressive work. How do you help build those coalitions? What's our role in them? How do we help them? How do we not see ourselves as helping, but actually participate in a meaningful way in that kind of work?
Mm-hmm. Thank you. That's quite insightful. Are there final comments? We're right up to the wire here. Over here? Yes.
Good afternoon. Thank you. I'd like to thank Ms. Jacobs for the teachings of the two-row wampum. It's very sacred. I'm a student here, and I came to take notes. And so I can put it in my journal for law and happiness that I take with part-time. And this was a very important session I wanted to attend. So, and in listening here to all the people on the panel and the comments from the room, and about getting in on the last bit of the ladies from I Don't Know More, and we're talking about social change here. But as an Indigenous woman, the part of the change that I'm trying to be is actually on the ground and trying to make a difference. Because the change doesn't happen at high levels, and it doesn't happen through nice words, and it doesn't happen through nice speeches. It happens in the streets, and it happens in the communities. It happens in academia, the law schools, the curriculum. It's all very race-based. I Don't Know More has brought out the racism in this country, the true feelings of the people that were veiled. And you see that in this city, in your organizations, in the government cutting funds, cutting programs. Our women are being targeted more, our men are being targeted more. You see this racism everywhere. You see it in this law school, and that's the truth. It's very much here. When you want to mention resources in a class, you want to mention I Don't Know More, you want to mention protest, you want to mention Indian Act, you know you're going to get hit with stuff. It's very much here, and this change that we talk about in these law schools and in our institutions, and us sitting in this room here, you can talk about it, but it's not going to happen unless there's movement on the ground, and that's standing with the people who are affected and the marginalized. And it's sad that as Aboriginal people, we have to put ourselves in that category when we're the first people here in this land. So, yes, us as lawyers sitting here talking about, yes, we need to do this, we need to do this. How is this going to happen, right? How does this happen instead of talking about it at a conference? Do we protest outside our law school to have inclusion of our treaties and our residential school survivors and the experience taught in this law school, in other law schools, mandatory in this system? how do we do that? That's kind of the question I'm asking to all of you, because we need that guidance and we need someone going forward with this.
Are there
Yeah.
panel members who
Yep.
wish to speak to that?
Yeah, thanks, Mary. And I think what you're saying about the actions, because it is the actions on the ground where the change is happening. It is happening, and sometimes it's hard to what I said in my presentation about separating myself as an activist or as a lawyer, as a woman or as a Mohawk woman, that it's all the same. And taking the risks, because that's a big part of it, is, and having a voice and being able to say in the front lines, as you're standing on your land and your territory, or protecting the women, the work with the missing women and murdered women, and taking a stand and standing up to the police and saying, well, what are you doing about it? Because you're part of the problem here. You're part of the system that isn't doing anything. You're part of the system that is part of the racialized systemic problems. So then what do? You stand up and you got to say it. You got to say it. You got to say it. That's the only thing I can say, and to not have fear. Because that's one of the things that stops us from having a voice, is being afraid of what you need to say. So thank you for standing up.
Mm-hmm. Well, thank you to all our panelists, Bev Kasari, Gwen, and Esther, and to everyone who's been present. Thank you very much.